It's now my great pleasure to welcome our next speaker, the Victorian Legal Services Commissioner and CEO of the Board, Fiona McLeay. Fiona was appointed in 2017 and commenced the role in January of 2018. Fiona is the former CEO of Justice Connect and was previously the General Counsel at World Vision and Special Counsel at Clayton Utz. She has an LLB from the University of New South Wales, as well as several other law and business qualifications. As the regulator here in Victoria, she oversees 23,000 plus practising lawyers. The VLSBC is also responsible for the maintenance of professional standards, addressing concerns of clients of law practices and lawyers, ensuring adequate management of trust accounts, and ensuring the uniform law is implemented effectively here in Victoria. At the LIV, we work very closely with Fiona and her staff, as well as the board, and we welcome her to address us today on the challenges, opportunities and expectations of the Victorian regulator. Thank you very much. Thanks, Fiona.
Thank you, Adam. It's great to be here this morning on the traditional lands of the Wurundjeri people of the Kulin Nations, to whom I pay my respects, and whose elders past, present and emerging I acknowledge. Thank you for the invitation, Sam Pandya, and for the welcome, Adam. It's a great delight to be amongst you again. I've been spending quite a bit of time, particularly in the last 12 months, travelling around the state and the suburbs, talking to as many of you as I can, most recently doing that with the LIV. Adam and Sam and Stuart Webb and I visited a number of regional towns towards the end of last year and had a really terrific time hearing from lawyers about their daily lives and the issues that confront them. So I found that really useful, and that's been informing some of the things that I'll share with you about today. So I want to cover a few topics. Let's start with technology. If you go to this website, Do Not Pay, you'll find what claims to be the world's first robot lawyer. It's actually a chatbot and an app combined together that you download, and as you'll see from the website, things you can do include fight corporations, beat bureaucracy, find hidden money, which sounds great, and sue anyone. I'm not entirely sure what that means. I'm not sure who anyone would be, but anyway. It seems a bit crude, doesn't it? But if you look at it a bit more closely, it in fact offers an example of how certain simple legal processes can be automated in a fairly easy way. Most recently, the tool was expanded to include 1,000 discrete legal tasks, including lodging a workplace discrimination complaint or cancelling an online marketing trial. Now, you'll be relieved to know that this operates in the US and in the UK, not yet in Australia. It was actually developed by a self-styled entrepreneur when he was 17 years old. And last year, Facebook's backers gave him $4.6 million to develop it further. Overall, it's estimated that $1.5 billion was invested in legal tech innovation in just the first 9 months of last year. So I think this idea, the robot lawyer, apart from perhaps leading some of us to be concerned about what that might mean for our daily practice, it also raises other questions of greater complexity. Will merely human lawyers be able to offer something that an intelligent piece of software can't? And what might that be? Of course, every profession's asking itself the same question. I think perhaps part of the answer for lawyers might lie, ironically, in our ability to think beyond the letter of the law. Machines like this one follow rules. In fact, that's what underpins the way they work. And a good lawyer is good at following rules. I'm not suggesting that you shouldn't do that for a moment. But I think that we are, as a profession, at a point in history where just following the rules is not going to be enough. I think the real challenge that the profession faces in 2020 is not about technology, it's actually about ethics. I think we need to ask ourselves some questions. What does a good lawyer look like? What makes a lawyer worthy of public trust? And what are the values that we want to bring to our work in the profession? So I'm going to talk to you for the next few minutes about some of the ways at the Board and Commissioner that we're trying to help the profession as you work through these questions. I'd also like to ask you how you view these priorities that I'll lay out for you and how you think we can best serve the profession. I'll raise a couple of questions along the way and then leave some time at the end for some questions and discussion, so keep that in mind through my remarks. So I don't know about you, when you hear the word ethics, my mind goes back to law school. It was one of the subjects that I was really interested to do. I was looking forward to it. I consider myself a values-driven person, and I got into law, like I'm sure many, if not all of you, because I wanted to do some good in the world. And I thought that the ethics classes would be a chance to think through some of the thorny issues in the law, wrestle with some of the dilemmas I might face, and learn more about what it means to be a lawyer and act well in the real world. Well, ethics classes turned out to be quite different. Maybe you had a similar experience. It was dry and it was detached, and it was focused on learning the rules and the exceptions to the rules. In fact, ironically for me, studying the values and morals of the profession was actually demoralising. I'm not the only one that has this experience. Recently, 12 law professors from around the country wrote in a submission to Her Honour Margaret McMurdo, leading the Victorian Royal Commission into Management of Police Informants. In their submission, they link what the Royal Commission is currently dealing with to what they see as the inadequacy of legal ethics education in this country. They say this has tended to, quote, focus on case law and the rules of professional conduct. And they note that, quote, students are educated to look for exceptions rather than innately value adherence to a particular ethical principle. They advocate what they call innovative approaches that emphasise values awareness. And they say students should be encouraged to develop a broader ethical framework that goes beyond simply learning the rules. It's this broader ethical framework that I felt was missing from my ethics classes as I look back. Now, of course, as the regulator, I'm very much focused on the rules of professional conduct. It's my job to monitor them and to respond to breaches. But I entirely agree with the submission of the ethics professors that neither the profession nor the public is well served by a narrow focus on what lawyers can and can't get away with. One of my priorities this year is to look for, in the words of the professors writing this submission, innovative approaches to these questions and approaches that emphasise values awareness. I think this is an urgent task, and I think it's a task for all of us, not just me as the regulator. There's no doubt, as others have mentioned this morning, that the reputation of the profession has taken a bit of a battering in the wake of the events leading up to the Royal Commission, and public trust in many institutions is at an all-time low. I think these hits to the reputation of the legal profession are a great shame. It undermines the good and important work that lawyers do every day without much attention, and also because ultimately it undermines public trust in the law itself. As a person who hears complaints about Victorian lawyers, though, I'm pleased to tell you that our profession generally meets a very high standard. In 2018-19, we finalised 1,784 complaints. Most of those are in the area of family law. About a quarter of complaints come from here. Some of the reasons for that, I think, are clear from Justice Olstringen's speech earlier today. There is so much pressure on that system and so much anguish often in those kinds of cases that come before it. The level of complaints in that area largely reflect the nature of the jurisdiction. They don't suggest that family law practitioners are less ethical than any others. The most common types of complaints were about billing. Around 28% of complaints allege overcharging. Not that many of them are found to be that when we dig into them. But allegations of dishonesty or misleading conduct made up just 6% of complaints. The reality is that most lawyers in Victoria operate with care and integrity. Most lawyers in Victoria strive to put the best interests of their clients front and centre. But I want to challenge you today and suggest that just doing this is not enough. Robert Fitzgerald recently gave a speech to the annual Australasian Legal Regulators Conference. Various Royal Commissions, he said, have exposed that short-term advice by lawyers, ostensibly in the best interest of the client, actually contributed to the long-term detriment of that client. He went on to ask how many today would claim that much of the advice given to institutions, say 20 or 30 years ago, in defence of allegations and claims in relation to child sexual abuse, have ultimately proved to be in the best interests of those institutional clients. The now infamous Ellis defence is an example of this. If there's a lesson to be learned from the Royal Commission into institutional responses to child sexual abuse, from the Banking Royal Commission and from other more global phenomenon, stretching back to the global financial crisis and forward to the Me Too movement, the lesson must surely be that ethics and culture matter. They matter more than the rules. Rules without ethics and adrift from culture are meaningless. It's how we operate as a profession, the standards we hold ourselves to, the behaviours we expect from one another, what we tolerate and refuse to tolerate. I think these determine three crucial things. They determine the quality of life for people within the profession, for lawyers and your staff and colleagues. They determine the quality of the work that lawyers do, and in turn the public's experience of lawyers. And they'll determine ultimately the reputation of the profession itself. So how do we improve ethics and culture in the law? I think we can start by encouraging lawyers to step back from a close focus on the rules and exceptions to ask a question: what kind of lawyer do I want to be? I think this question will move us in the right direction. In my experience, most lawyers go into the profession for good reasons. As Adam mentioned, before becoming a Legal Services Commissioner and Board CEO, I was the CEO at Justice Connect, which, as you all know, is a pro bono legal assistance organisation. And before that, I managed the pro bono practice in the Melbourne office of a national law firm. In both roles, I was repeatedly struck by the generosity of lawyers whose commitment to pro bono meant that avenues to justice could be opened up for people who would otherwise miss out. While I worked at the law firm, I never had a lawyer refuse to take a pro bono matter because they didn't think they should, or they rejected the idea that they had an obligation to do it. Many, in fact, told me that pro bono work was a highlight of their practice and that it connected them with the reasons they were drawn to the law in the first place. I think that belief in justice, in procedural fairness, in equal access, and to the rule of law itself motivates so many people in our profession, from those working on criminal cases right through to technical commercial disputes. I think that building a healthy culture in the Victorian legal profession means calling ourselves back to this original motivating belief about the importance of the law. So, in the time remaining this morning, I just want to outline a few things that we're doing more specifically at the Commissioner and Board to help improve ethics and culture across the profession. I want to talk briefly about our regulatory approach, discuss some work we're doing on sexual harassment and on lawyer wellbeing, and talk briefly about a consumer advisory committee that we've established, as well as return to the theme of technology. So our regulatory approach, we launched a new strategy last year, and alongside this, a regulatory approach statement. Both are on our website, and I encourage you to check those out. The regulatory approach statement has 6 principles to guide how we respond to immediate and emerging issues. The theme, though, underpinning those principles is that we want, wherever possible, to focus on prevention and mitigation of bad behaviour and poor performance, and less on punishment, although be assured we'll do that if we need to. As I mentioned earlier, though, we know that most lawyers do the right thing, or they're sincerely trying to. For these lawyers, in the words of a former colleague of mine, Murray Baird, from the Australian Charities Not-for-Profits Commission, as he was then, we want to be a light touch, but not a soft touch. To use another analogy, also one that I've stolen from Murray Baird, we want to help lawyers swim between the flags, to know the standards and behaviours that we expect, so that the lawyers can have the confidence to navigate the waters of legal practice without fear of the regulator. If you go outside the flags, however, we will be watching closely. We're working very closely with the Law Institute to develop preventative, educative and supportive programs to help lawyers understand where the flags are and get help and support when they need it, when they're getting too close to the flags. So on to the work we're doing in sexual harassment. It's one of two areas that we're focusing on to try and improve the culture within the profession. As you know, last year I conducted a survey of the Victorian legal profession. I'll be releasing the full report next month, but I can tell you that some of the results are concerning. It showed that almost 2/3 of female respondents and 12% of males experienced sexual harassment at work. In the vast majority of cases, the perpetrator was male, and in 70% of cases, the perpetrator was in a position of seniority to the victim. And perhaps most disturbingly, women in their first 5 years of practice are much more likely to experience sexual harassment than at any other time in their careers. There's nothing in this result that suggests that this is the behaviour of a dying breed, as some have suggested to me. Indeed, I found some of these results deeply disturbing. Sexual harassment impacts not only on the mental health of those who experience it, it not only makes workplaces unsafe and unpleasant places to be in, but it creates a big disincentive, particularly for women, to join or stay in the profession. As I mentioned, next month I'll release the full report, along with my regulatory strategy in response. And in the coming weeks, I'm going to be meeting with leaders all across the profession, from the judiciary through to professional associations, managers of law firms and so on, to share the results and seek their support to stand with me to address this issue. We've seen the power of the profession collaborating together in disaster legal help. It shows the profession at its finest. I'm calling out to the profession to stand with me in response to these results in the sexual harassment survey as well. Related to this is our work on lawyer wellbeing. In 1995, Justice Michael Kirby wrote an essay called "Judicial Stress, an Unmentionable Topic." A fellow member of the judiciary told him that this would be, and I quote, "a godsend to whingers" for him to even raise the idea. I think it's fair to say that across the Australian workforce, and perhaps even the judiciary, the stigma attached to admitting to a mental health problem has been steadily decreasing. And one thing I've noticed over 30 years or so in the legal sector, and especially during my time in this role, is that we are talking more and more about helping lawyers cope with what can be at times an incredibly demanding and stressful profession. In my opinion, it's great that we're talking about this. It's where the conversation should start. But I don't think it's where the conversation should end. Stress is a symptom, after all, and it has a cause. Unwell lawyers don't exist in isolation. They're part of a broader system. And I think we need to shift the conversation away from a focus solely on how to help lawyers cope with the system to one where we look to change the system itself. The board has had a progressive mental health policy in place since 2011, where we encourage lawyers with a mental health condition to seek treatment voluntarily, and we only require disclosure where a mental impairment affects the lawyer's capacity to engage in practice. But I think that there's more that we can be doing, and I've been consulting with a wide range of people in the legal community, from law students to legal assistants to solicitors, barristers and judges, to hear about their experience and their ideas about how to do things better. In my conversations, some clear themes have emerged, and perhaps these resonate with you. I think the pressures on lawyers come from three directions. There are vertical pressures that come from the top down, from employers, from firms, from clients and so on, and also horizontal pressures. Law is very competitive from beginning to end. You compete to get into law school, you compete with your fellow students for academic achievement, and then you compete for a job after graduation. You compete with your colleagues for clients and promotions, and of course you compete with your opponents in the day-to-day cut and thrust of practice. Of course, we saw the gold standard perhaps of pressurised environments during the Hayne Royal Commission. Lawyers working 18-hour days with utterly unrealistic expectations placed on them by clients and by the firms themselves on their staff in an effort to meet deadlines. But even at the best of times, client expectations and billing systems can help to ensure that the pressure never really ceases. And I think we do see a link to the issue of underpayments, which has been much discussed in the press recently. Some observers have noted that graduate staff on $80,000 a year can be earning less than a Coles shelf stacker on a per-hour basis. And quite a few firms are undertaking underpayment reviews in response. It's a complicated debate, and perhaps one we can explore a bit later on in the question time if there's time. But I do wonder if the silent acceptance of long, long hours, 10, 12, 14-hour days over days, weeks and months, is something that's getting much harder to justify in the current climate. And is it something that we should be trying to justify at all? I see the results of overworked and stressed lawyers regularly. Those lawyers are far more likely to make mistakes, and they're likely to cover them up once they make them. Clients suffer as a consequence, and sometimes the lawyer's professional standing is destroyed. I think it's very hard to demand ethical behaviour of staff when they're being pushed perhaps beyond what is healthy or fair. I said before that the pressure on lawyers come from three directions. I've mentioned some of the vertical and horizontal pressures, but there's also internal pressures. As a breed, lawyers tend to place very high expectations on themselves. We're often perfectionists, afraid to make mistakes, self-critical. And from a mental health perspective, when you combine these internal and external sources of stress, you've got a very volatile combination. So with all this in mind, I think we need to take a real fresh look at the sector from top to bottom, the way we work, how we train and supervise young lawyers, our assumptions about what clients expect, how we structure practices, how we bill, and even how the law is made. One of the ways that we are going to be looking at practice is the establishment of a Consumer Advisory Committee, a committee of the board that will be made up of people who are experts in understanding the experience of the consumer, the client, with lawyers. We recognise at the board and commissioner that we know very little actually about people who use lawyers. We know about the very small fraction that complain to us, but we want to understand much better the experience of people who don't come to our attention. We want to understand the good experience and the bad experiences. We will be commissioning research and issuing reports and sharing that with the profession so that you can get a better understanding of what clients think about the services that you provide, things that you're doing well that you should keep doing more of, and things that clients find dissatisfying. And finally, I'd like to return to the robot lawyer that I mentioned at the beginning and briefly discuss the impact of technology on the profession. As science fiction increasingly becomes fact, I think we need to avoid two equal and opposite errors. The first error is to accept uncritically every new advance that comes along without any regard to ethical and cultural implications. But the other error is to instinctively resist new technologies and the massive advantages they can bring in terms of efficiency, cost, and access to justice. As board CEO and Commissioner, I too need to calibrate my response to technology and advances. So with that in mind, I've laid out a set of commitments in this area. I want to be open to emerging ideas and issues and supportive of new ways of working that may involve technology. I'll be clear about what is negotiable and what is not, and continue to review this as technological advances continue to change. I'll continue to work with consumers to help consumers understand the profession itself, to help consumers understand the value of law and lawyers and how best to access it. And I'll continue to work closely with the profession on understanding the challenges raised by technology, as well as the opportunities, and finding solutions together. In pursuit of this, I last year appointed one of our senior managers, Jenny Pakula, as our Manager of Innovation and Consumer Engagement. And recently we've launched what we call the Innovation Inbox, which is a way for lawyers and legal services organisations to work with us to explore how regulation might change their business models. We've helped dozens of organisations already understand how the law applies to their idea and what our regulatory approach would be to the issues that are raised. It's pretty simple. If you've got an idea, contact us online and we'll have a conversation about your idea, the proposed service model or idea, and discuss any concerns we might have and talk through our way forward. So far, we've had applicants contacting us about online mediation platforms, the use of chatbots, different pricing and remuneration models, managing possible conflicts through information barriers, and online self-help platforms. So I think together we can make technology work well for both the profession and the public. So I said at the start that I was keen to hear your views. I welcome your feedback on any of these new initiatives, and I'm keen to hear your thoughts on the questions that I posed earlier. What does a good lawyer look like? What makes a lawyer worthy of public trust? And what are the human values we want to bring to our work in the profession? Thanks.
Thank you, Fiona. We probably have time for one or two quick questions if anyone does have any of the Commissioner.
Mental health. I received a letter from your office, your signature, which responded to my renewal of my practising certificate a year or two ago. And in that process, I chose to disclose that I had been suffering from depression. And your letter expressed an acknowledgement of that disclosure, and I was gratefully appreciative of it, so thank you. And I welcome or encourage anyone else to have confidence in the system as well. Thank you.
Thank you. Thank you. I appreciate the comments. Anything else? You know where to find me. I'm just across the road, and I am keen to hear from you. So whether it's at an event like this, when I'm out and about, or contact me via email, I'm really keen to hear from you. Thanks.